defending different areas, mental patients or asylum seekers or homeless people, and they also use the courts for trying to obtain suitable solutions when they have not been able to do so in the political forum. They see that the legal forum is also a way of achieving progress for vulnerable members of society. So there is an explosion all over the world in this kind of fundamental rights litigation. And the courts have to find a way of dealing with it, and the legislators have to find a way of dealing with it. But I would agree, it's not just the problem of the European Court of Human Rights. It's what is happening in Strasbourg is illustrative of a phenomenon that you find also on the national level. And it's not a bad phenomenon in a sense. It's a positive development as far as society and progress of society is concerned, but we have to manage it so that you don't in turn have other victims of this development. The old court, under the old system, it is true, dealt with 100 cases per year. There was a hearing in every case, and cases were dealt with usually within 12 months. So there was no problem. But behind that, there was the European Commission of Human Rights. And they, at the time, had what was considered to be an unacceptable backlog. It had gone up from 2,000 to 4,000 applications at the time. And it was taking between 3 or 4 years from when an application was lodged to when it was dealt with finally, if it hadn't been thrown out as being obviously hopeless. But the applications that did have some merit to them. So there was, even in the old system, there was a problem, but it was at still at the filtering level with the Commission. And the other, well, my ideas are still in a very unformed sense. Maybe you can argue this way and adapt it that way. I was just throwing out some ideas as to some of the directions that could be taken, and of course there will be reactions from academic writers, from the non-governmental organizations, from the court, and from the the non-governmental organizations as well. And so at the end of the day, what comes out as the solution will be a lot different. I mean, it's like the raw material that goes in is then mixed up and different ideas influence, there are compromises. But I think the debate should be started now before it gets too late. I don't think one can say, we have protocol number 14, let us see if protocol number 14 works. This is the solution that certain governments, the Turks and the Russians want, because they're quite happy that cases should take years and years to be dealt with. I don't think so. I think the problem is an urgent one. I don't claim to have the whole solution, just some initial ideas that could be examined. What you will hear the non-governmental organizations say, and there is some merit in what they say, they will say that it's unfair that the right of individual petition, which was developed and evolved from nothing into the soul of the system, should now be cut down for what they say are purely financial reasons. They say human rights and the access of the citizen, the ordinary person, should not be damaged, should not be weakened for purely financial reasons. And they say that every alleged victim of a human right is entitled to the same treatment. And in particular, they don't like the pilot case procedure, where you have a general problem. Let's take the first pilot judgment procedure case, which was Broniewski against Poland, which concerned the legislative scheme so restitution of property which had been lost after the Second World War, and the scheme wasn't working, mainly because of administrative obstruction. The legislation was very good. It's simply that the courts and the administrative authorities were obstructing the application of the legislation. And so the court found a violation of the right of property. And it took one illustrative case, froze all the other cases, and then waited until amending legislation had been introduced and dismissed all the cases that had been frozen. And this procedure was criticized by non-governmental organizations, saying, here you had hundreds and hundreds of people who had all been victims of the same violation of human rights by the Polish state. They should be entitled to be treated in the same way, all of them. Why should just one privileged applicant get the chance of going to a judgment and damages being awarded, and the other 500 or 1,000 not? They are all victims. They should all be treated in the same way. And they say also the solution is to force the governments to behave better. That's the way to reduce the number of applications coming in. You must oblige the governments to behave better. And my answer to all this is, one, if you want all applications to be more, as far as possible, dealt with on their merits, and even as regards admissibility to be examined in reasonable detail, then you will need a monster court in Strasbourg, an absolute monster court. And the governments are not willing to pay for this. They are not willing to pay. That is quite clear. And I would then say, secondly, I personally don't think that the idea of a monster court in Strasbourg is in any way desirable. I personally think it would be better to transfer as much back to the national system as possible, and to only deal with, on the international level, those cases which raise a real human rights problem. That may be an individual case, the disappearance cases in Turkey, torture, ill treatment, etc., where there's no general question of interpretation of the convention. It's quite clear legally, but you have a serious problem of human dignity. Or where maybe it's a trivial question in terms of human dignity, but there's a big question of interpretation of an article. There, again, you can deal with those. But otherwise, I don't think you should have a court in Strasbourg that goes into the merits of every alleged violation of human rights that might occur in the 47 countries. There are 800 million people now in the community covered by this system, this legal system, and the convention covers just about every area of human activity, every area of law. The scope is phenomenal and increasing the whole time. So I don't think it's desirable even to have a monster court. And thirdly, the argument every applicant should be treated the same, every victim should be treated the same. Well, this is an idealistic point of view which has a certain logic to it. But I would say, in real terms, it's romantic and wholly unrealistic. By insisting on this line, the end result will be that there will be no remedy at all for anyone. I said there are 150,000 cases at the moment. It's going up by 1,500 cases every month, 25,000 cases a year. The real victims, people who really have suffered, they are having to wait years. So this theoretical construct of equality will lead to a situation where real victims don't get a remedy, and in the end, where no one gets a remedy. I'm a believer in realpolitik, also in relation to human rights, and it's better to have a good solution that works rather than a perfect solution that doesn't work at all. For subsidiarity, it's true that in more and more national legal systems, the legislators are more aware of fundamental rights issues, the national judges are more alright, even the local town councils. So it's true, there is a greater awareness. And so there is, the level is going up in many countries, not in all of them. I mean, there's 47 countries, and the human rights situation, although one shouldn't say this, it does vary considerably from country to country. All countries are not the same. Some are better than others, that's quite clear. I prefer to live in some countries rather than others, if I had a choice as far as human rights protection was concerned. It is true it is getting better, but you will still have the flood of inadmissible applications coming in, and it will still keep going, even though it gets better. I saw this with my own country, the United Kingdom, which, as you're probably aware, had no constitution at all, no written constitution, no Charter of Human Rights. Up until 1998, the Constitutional Court of the United Kingdom was in Strasbourg. People who had a fundamental rights problem in the United Kingdom, they had to come to Strasbourg. And a lot of the leading cases raising principal issues on all sorts of things, fair trial, free speech, they were British cases. It's not because Britain was the worst boy in the class. It's not that. It's just that there was no way that these cases could be litigated in the national system. After 1998, the European Convention of Human Rights was made part of national law, and now you find Supreme Court judgments, which I think are actually, on the whole, better drafted, and they analyse the Convention better than the Strasbourg Court does in many instances. But there are still many, there are fewer cases, well-founded cases coming in, but the number of cases from Britain is still going, because when people lose at home, they will still come to Strasbourg. And as I said, it is a tendency in all countries for more. So I don't think that the rising level of compliance with the Convention in real terms in the member states is going to have as a consequence a reduction in the sheer mass of applications coming in, so that in any event you're going to have to radically reform the screening and initial filtering. Who does that and how it's done, I don't know. We can talk about that. Yeah. Right.
But before they're going for dinner, you still have some time. We still have some time for questions, so we can collect a couple, and you're not really welcome to raise some points. Please. There's a question.
My name is Matjaž Mecenovic.
You have to shout because I have.
My name is Matjaž Mecenovic, and I work as a contracted agent of the HQ U4 in Sarajevo. And part of my business is also very small part judicial reform. I have now almost 10 years of experience with reforming the fallen states in different ways. And as far as you addressed the large number of cases here, I discussed this recently with the PhD students from Exeter University in the UK. And one of the conclusions from this debate was that actually one of the reasons behind, in many cases, is lack of interest of the countries. Not just that they don't want to augment, for instance, the office of the registry or the court or any other, but simply the lack of interest, because the judgments from the ECHR actually affects, in many ways, the lawmakers, the executive powers in the countries, and therefore I would say that this might be also a case behind Russia, for instance, since you pointed out this. Then what Professor Jambrecht mentioned, maybe he remembers that we had very similar discussion with Dr. Wildhaber some years ago. I believe, and this comes from practice, and my reference is also Dr. Heinz Wetscherer from University of Vienna, that mixing two systems, basically Anglo-Saxon and continental system, actually leads into a variety of troubles. And personally, I faced a lot of these troubles, and that goes, for instance, Sejdic-Finci case, Sejdic-Finci against BIH. I'm sure that you are actually aware of this case. Just to give you a hint, it is actually systematic exclusion of the minorities from the constitution of BIH. What I learned is actually that mixing of two different systems, and then such a mixture is applied somehow into the system that was in principle actually a communist legal system of former Yugoslavia, gives no or very limited results. I speak about the practical judiciary, not about the academics and professors at the universities. A lot of people are unable actually to understand what are the principles from the Anglo-Saxon system, what are the new or democratic principles from the continental system. And there is also something that is very different, and this is somehow obstructing the justice, if I may say so. Actually very different cultural, political, social, legal backgrounds of the participants in this game. And therefore people are not only afraid, they simply don't know. And I met a bunch of judges in BIH and also from Kosovo that were simply unable, again, unable to understand what is actually the outcome of this Sejdic-Finci case and several other cases brought to the HC by citizens of Bosnia and Herzegovina. And that misunderstanding or in conjunction with different backgrounds extends also to the subsidiarity you mentioned. Basically implementing European Convention on Human Rights or other international legal acts in domestic legislation by the lawmakers is one thing, but implementing or using this kind of law as with the rule of subsidiarity, it's a, I would say, sword with two very sharp edges. Maybe this is not really applicable for the EU countries, but my experience linked with the HC and to a certain extent also with ICTY, you just mentioned it.
Okay.
And basically that concludes my questions.
Thank you very much for this very interesting, very broad question. We should still invite some others, if there are others.
You mentioned that in years there has been a raise of solved cases, but would you say that the quality of judgments remains, or are solved cases also kind of fast delivering solutions or judgments? Because what we are facing in Slovenia at the moment reflects also the situation that you're mentioning in Strasbourg.
Mr. Mahoney is right authority to answer this question.
Maybe one more
to be
question?
Honest, well, let's take the last question first. I think there is a problem, yes. The Strasbourg court is having to balance two priorities. One is quantity, the right of every applicant to get an answer within a reasonable time.
And you mentioned time like 10 years or never.
They have, this is since I've left, this is a recent decision,
The recent.
2010. And the other is quality, yes, because there is the applicant in the individual case who is entitled to a proper, reasoned judgment in his or her case. But the role of the Strasbourg court is also constructing a kind of Europe-wide common law, not common law in the British sense, but common in the sense of shared, European-wide common law of human rights, not imposing uniform solutions, not in the way the EU law provides a common law, but where principles and values are stated in given contexts, which national judges then have to apply within their own national legal system, with their own legal traditions and cultures, whether it be Nordic, Anglo-Saxon, continental, Eastern Europe, Central. The whole thing about the European Convention is it doesn't impose uniformity, it imposes an obligation of result, and that result can be achieved in many ways. But it is clear that the judgments must be understandable, not just for that particular applicant, in the big cases, right, the ones that go to judgment, must be understandable not to that particular applicant or that particular defendant government, but must be understandable to all the governments and all the judges in all the 47 member states, if the idea is to create a jurisprudence which is applicable and can be used by all the national judges and national administration. So you do need a high quality jurisprudence because it serves a pedagogic purpose as well as just a dispute settlement purpose. And the problem is they are running out of time. In the old days, yes, cases were dealt with in preparatory meetings, there were long deliberations, a full exchange of views. Now they have barely 2 hours after the hearing in which to deliberate, bang bang, and then the text will be produced, and then they have perhaps an hour. Yes, this is the problem at the moment, and one of the dangers is that the quality will go down because the judgments are not formally binding on the national judges in the way that the judgments of the European Court of Justice are. Preliminary rulings are formally binding on national courts. No, the Strasbourg jurisprudence has to convince the national judges. It has to be, they have to be willing to apply. So you do need the quality, and there is a big risk at the moment that unless they keep sufficient time for the big cases, they will lose quality. And this is why they have adopted this principle of priority, where they have said, we will sacrifice this principle that every applicant is entitled to an answer within a reasonable time. We cannot do that anymore, and therefore we will only guarantee an answer within a reasonable time to cases which are on the priority list, which satisfy the priority consideration. So this, but there is this risk, yes. Whether the quality has gone down or not, I leave that to outsiders to say. It's not up to me to say whether quality has been maintained or gone down or gone up in the meantime, but there is a real risk. I don't know, Peter, do you want to say to the first question? For the first question, well, I tried to say there is a difference between the contracting states, and one of the differences is whether there is what one might call a culture of human rights that has permeated the fabric of the country, in the sense that you get it at law school, if you do law, or politics, and then people in parliament are aware, people in the ministries are aware, people in the local town councils are aware, in the schools, in the courts, and it's growing. In some, you do have this culture. In other countries, the culture doesn't exist, and this is why you get, in Russia, for example, judgments are dismissed as political by the Russian government. What they mean is they don't like the judgment. Any judgment they don't like is political, because somehow or another the politics of the country has fallen foul of the convention. But in the case of the Ilashku against Moldova and Russia concerning region known Transnistria, a bit like the Loisedu case, the question was whether Russia could be found responsible for what was happening in this country because of the political, financial and military influence exercised by Russia over what was technically speaking part of another country, Moldova. But ordinary Moldovans had no access to this because the Russian army was there. Well, the old 14th Red Army withdrew into the... And a judgment by the court finding that Russia was responsible for what went on in this country because of its military, political and financial. That judgment was denounced as political. But that's... this is, I would say, inevitable. And I would say also this question of cultures, the fact that you have Anglo-Saxon legal culture and continental legal culture, and therefore the judgments are incomprehensible. You don't know what they mean, whether they're dancing on this foot or that foot. I would say that I have never, ever seen any problem of that kind from the inside. And also, I would say it's a misapprehension to divide the two cultures that way. French administrative law is purely judge-made by the Conseil d'État. The United Kingdom has more and more written legislation. There has been a bringing together, and indeed in the deliberations I have never seen any divide along such cultural lines at all, ever. Most of the principles, you find them that are expressed in the European Convention on Human Rights are found in any civilized democratic system. They may have developed historically, but they are there, and the judgments on the whole represent a fusion of different influences, and my own view is that it's a relatively harmonious fusion. The margin of appreciation comes from German law, the proportionality, and others from German and French administrative law. There's the concept of reasonableness is from Anglo-Saxon law, but these are merged into, I find on the whole, a coherent case law. It may be that there are judgments that are not understandable. I'm quite willing to accept that. No one is perfect, and I think it was at the Shedovich case, I myself remember not feeling particularly happy when I read that judgment with some of the reasoning that's contained in it. But that you find anywhere. When you have different chambers, different judges, sometimes you agree, sometimes you don't. Some of the judgments are well drafted, some of them are less well drafted. Sometimes you can clearly see what the message is, sometimes you can't. But that's got nothing to do with the presence of different legal cultures. That's just an accident de parcours, if you like, that you'll find in any court. That's what I would say. I can't really answer the question about whether the problem of applying the case law is due to the presence of two large legal families. I can't really answer that question because I, from the inside, have never ever seen any problem of that kind. It may well be that you will get lawyers, blinkered lawyers, American or British lawyers, who think that the only way you can ever analyse problems is in common law terms, trying to analyse Strasbourg case law in that sense, but that's their problem.